This course provides a brief overview of HIPAA. Throughout the course, you will watch some short videos. There will be some questions for you to answer. You must score at least 70% correct to pass this course. Here's an outline of what we'll cover in this course. Let's begin with the first topic. Introduction and Scope. The Health Insurance Portability and Accountability Act, commonly known as HIPAA, provides a basic set of protections for people's health data. HIPAA was passed by the United States Congress in 1996. It was amended and strengthened by the HITECH Act in 2009. The Department of Health and Human Services, HHS, has created regulations under HIPAA, and it enforces HIPAA. Whom does HIPAA apply to? HIPAA applies to covered entities and business associates. A covered entity is a healthcare provider, health plan, or healthcare clearinghouse. A business associate is a person or entity that creates, receives, maintains, or transmits protected health information in fulfilling certain functions for a covered entity or for another business associate. Business associates are directly subject to the HIPAA security rule and to the use and disclosure provisions of the HIPAA privacy rule. Whenever business associates receive protected health information, or PHI for short, they must have a business associate agreement with the provider of the PHI. The agreement must include a set of contractual requirements for protecting the PHI. A subcontractor of a business associate is regulated by HIPAA in the same way as a business associate. If a business associate provides PHI to a subcontractor, there must be a business associate agreement. Please answer the following question. A physician provides PHI to a lawyer who handles her delinquent bills. Click on the box that describes the lawyer correctly, then click Submit. Correct. The lawyer is a business associate because the lawyer is receiving PHI from a covered entity to perform a function for the covered entity. The lawyer must be subject to a business associate agreement with the physician. The lawyer is directly regulated by HIPAA. Let's move on to the next topic. Protected Health Information, PHI. What does HIPAA apply to? HIPAA applies to Protected Health Information, or PHI for short. PHI is any individually identifiable health information in any form, oral, electronic, and paper. PHI is information that relates to any past, present, or future health condition, or to healthcare, or to payment for healthcare. Suppose the information pertains to this man. His name is Jay Gatsby. Is his health insurance information PHI? Yes. Is his photo PHI? Yes. Is his phone number PHI? Yes. PHI is identifiable when it identifies a person or provides a reasonable basis to identify a person. PHI can be de-identified and removed from HIPAA's coverage. But de-identification requires removal of 18 different types of identifiers or the use of an expert statistician to ensure that it cannot be re-identified. Please answer the following question. The following information is contained in a person's medical records. Select all items that are considered PHI, then click Submit. Correct. PHI is any individually identifiable health information in any form, oral, electronic, and paper. The photo is clearly identifiable to the person. The birth date and audio recording are also PHI because they can provide a reasonable basis to identify the person. The book isn't PHI. Let's move on to the next topic. Use and disclosure of PHI. HIPAA requires that people authorize uses and disclosures of their PHI. If the person says yes through a proper written and signed authorization, then the PHI can be used or disclosed. The authorization requires that people be informed about their rights. It must be signed and dated by the person or the person's representative. But there are a number of exceptions when people's authorization is not required. Examples include disclosures to comply with a legal requirement, to report abuse, and for treatment payment or healthcare operations. Unless an exception applies, PHI must be kept confidential. This means that it is improper to gossip about PHI to family or friends. The minimum necessary rule requires that only the minimum necessary PHI be accessed, used, or disclosed. This rule means that people can't use or disclose more PHI than what is required to accomplish the purpose it is needed for. Snooping into records out of curiosity is a violation of the minimum necessary rule. Snooping is a violation even if a person has access to those records, and even if a person doesn't disclose them to anyone. Please answer the following question. A person is involved in a car accident. An attorney requests the person's medical records relating to this accident. The person has provided authorization to release records for this purpose. What should be sent to the attorney? Select the correct answer, then click Submit. Correct. Only the medical records that pertain to the car accident should be sent to the attorney. Supplying more would exceed the person's authorization and violate the minimum necessary rule. Please answer the following question. Alex and Phil are twin brothers. Unfortunately, they are estranged and aren't talking. Phil is suffering from a rare liver disease. Alex wants to know more about Phil's condition, as Alex thinks he might also have the disease. Alex has access to Phil's medical records, but Alex doesn't need to see the records for his job. Under what circumstances can he look at Phil's records? Select the correct answer, then click Submit. Correct. HIPAA does not permit Alex to access Phil's medical records unless it is necessary to do his job. Just because Alex has access to the records is not sufficient. Alex must obtain the authorization of his brother to see the records. Let's move on to the next topic. Patient rights. HIPAA provides a set of rights to patients, including a right to be given a notice about the privacy practices of a covered entity. This notice is called a Notice of Privacy Practices, or NPP for short. People have a right to access their PHI and have a copy of it. This includes the right to an electronic copy if the PHI is stored in electronic form. People can request that the records be amended. This request can be denied, but people can still place a statement of disagreement in their file. People have the right to restrict certain uses or disclosures of their PHI. People can request an accounting of disclosures. This means that people can find out about certain disclosures of their PHI. And patients have a right to file a complaint to the covered entity or to the Department of Health and Human Services alleging a HIPAA violation, without being retaliated against for doing so. Covered entities, and not business associates, are the ones that administer the rights to patients. Although business associates don't administer these rights, they must do certain things to enable covered entities to administer them. For example, if a patient asks a covered entity for an accounting of disclosures, the list must also include disclosures made by business associates. So business associates must keep an accounting of disclosures to provide to the covered entity if a patient makes a request. Please answer the following question. A patient requests that his medical record be corrected to indicate that a lion attack caused his injuries. The covered entity denies the request. The patient asks to place a statement about his disagreement in the file. The covered entity also denies this request. What did the covered entity do wrong? Click on All That Apply, then click Submit. Correct. The patient only has a right to request that a record be corrected, and it is up to the covered entity to grant or deny the request. But if the covered entity denies the request, the patient has a right to place a statement of disagreement in the file, something the covered entity failed to do in this case. Please answer the following question. A patient contacts the covered entity and demands that she be provided an electronic copy of her record. The covered entity has the record in electronic form, but has a policy of only providing paper copies. What kind of copy is the patient entitled to receive? Select the correct answer, then click Submit. Correct. People have a right to an electronic copy if the PHI is stored in electronic form. Let's move on to the next topic. Security. For electronic PHI, or ePHI for short, the HIPAA security rule provides a detailed series of administrative, physical, and technical requirements. HIPAA's privacy rule requires safeguards of all PHI regardless of media type. Data security is a very difficult challenge. The threats out there are numerous and daunting. Studies show that cyber attacks are becoming more successful and frequent. Security incidents can cause enormous damage, sometimes millions of dollars of damage. Here are 5 key points that you should know in order to help your organization maintain good data security. The first key point is that data security doesn't just involve technical measures. It involves you. That's right, you. Many of the most common and most significant data security risks involve human behavior. That's why everyone needs to help out when it comes to data security. Create powerful passwords and protect them. What are some of the features of bad passwords? They're short. They're dictionary words or names. Create long passwords. Use all parts of your keyboard. That means you should use punctuation, use numbers, use capital and lowercase. Keep passwords safe. John decided to create the world's best password. It was 50 characters long with all sorts of special characters.
This is the best password ever.
But there was a problem. He couldn't remember it. So he decided to email it to himself. One day a hacker stole a smartphone and got the password. So find ways to make passwords that you can remember. And don't put passwords where they can be lost or accessed by others. Click with caution. What do the following things have in common? Walking on a tightrope high in the sky without a safety net. Taming a lion that hasn't eaten for a week. Swimming alone with sharks with a bleeding wound. Clicking on unknown documents or links. All of these are highly dangerous activities and require great caution. Any kind of attachment to an email could be infected with a virus. The vast majority of emails sent is spam, and more than 90% of it has links to potentially malicious material. Websites can infect your computer with a virus just by going to the site. There are tens of thousands of newly infected websites created every day. Keep data where it belongs. Anytime you move data, you create a risk. Think of security like a castle in which important data resides. It is dangerous whenever you take data outside of the castle walls. Be sure to follow your organization's policies and procedures for the use of portable electronic devices. These devices include laptops, USB drives, and DVDs. What do all these devices have in common? They are convenient, and they often get lost or stolen. Encrypt any personal or sensitive data that you put on a portable device. Throwing away data also means that it will go beyond the castle walls. Make sure that documents are shredded or properly disposed of. Keep in mind that getting rid of electronic data is tricky because it is hard to eliminate it entirely. Be vigilant. Look out for anything that looks weird or odd or troublesome. There are a lot of data security threats out there. Hackers are not just technical wizards, they are good con artists. They often get in by tricking one unsuspecting person into letting them inside the security castle. Don't be the person who opens the drawbridge. If anything about an email looks off or too generic, don't click on anything in it. If someone calls or emails you, they might not be who they say they are. Be suspicious. Check to make sure if you're in doubt. I have told you 5 key points about data security. Data security involves you. Create powerful passwords. Click with caution. Keep data where it belongs, and be vigilant. If you do these things, you'll go a long way toward keeping data secure. Please answer the following question. Mike puts personal data from work on a DVD. He plans to take it home and keep it locked in a safe. Is this adequate protection for the data? Correct. It is very risky to remove personal data from work on a portable device. At the very least, the data should be encrypted. Let's see what happened to foil Mike's plan. As Mike was driving home with the DVD, he stopped briefly to pick up milk at the convenience store. A thief broke into his car and stole the DVD. Because the data was unencrypted, the thief could access it. Please answer the following question. Brian gets an email from a friend with the subject funny. It just says, check this out, and has a link to a website. Brian is curious and wants a good laugh, so he clicks the link. He goes to a website that looks like this. Brian knows that his friend would never send him a link to such a site. But nothing bad happens to his computer. What should he do now? Correct. The site could have infected his computer with a virus. Viruses might show no signs at all that they have infected a computer. Sometimes they might not be detected by antivirus software. Brian should call for help immediately. Waiting will only make the problem worse. Let's move on to the next topic. Enforcement. The Office for Civil Rights at the Department of Health and Human Services handles the civil enforcement of HIPAA. Fines can be quite steep for HIPAA violations, up to $1.5 million per provision violated. There are also severe criminal penalties under HIPAA for violations with a malicious purpose. HIPAA does not have a private right of action, meaning that people whose HIPAA rights are violated cannot sue for damages, but they can still sue if certain state laws are violated. States have legal actions called torts, which authorize people to sue in certain situations where healthcare providers or others improperly disclose their PHI. Let's move on to the next topic. Data breach. HIPAA also has requirements in the event of a data breach. A data breach is an impermissible user disclosure that compromises the security or privacy of unsecured PHI. Unsecured PHI is PHI that isn't properly encrypted. In the event of a breach, a covered entity must notify people without reasonable delay, and no later than 60 days after discovering the breach. Covered entities must also notify HHS of the breach, and sometimes the media must be notified. When business associates suffer from a breach, they must notify the covered entities that supplied them with the PHI. Please answer the following question. At a business associate, a thief steals a document with the PHI of 5 patients. Click on the correct statements about who must report to whom. You may select more than one answer. Click Submit when done. Correct. The business associate must report the breach to the covered entity, and the covered entity must report the breach to HHS. Please answer the following question. Under HIPAA, how soon must people be notified about a data breach? Select the correct answer, then click Submit. Correct. People must be notified without reasonable delay or within 60 days. Let's move on to the next topic. Conclusion. This is just a brief overview of HIPAA. HIPAA is a complicated regulation with many requirements, backed up with powerful enforcement. Understanding HIPAA is of utmost importance to protect people's privacy and to protect your organization from the high costs of having a violation. Effective compliance with HIPAA depends upon you. Not only do you need to follow HIPAA, but you need to help out by being on the lookout for potential HIPAA issues. If you notice any user disclosure of PHI that isn't authorized, please report it immediately, and report anything suspicious that might be a sign of compromised data security. Congratulations, you passed!